Exxon versus Federal Trade Commission and Chevron. Now, I have both cases to go over, and I'm going to go ahead and interpret their languages, but the way that you had said it was the defense to go towards. I'm pretty sure one was the administration doesn't have a right to dictate or decide jurisdiction or the case or what constitutionality is. I think that's why I'm calling you, is because I'm drawing a blank.
So the Chevron hearing, I do remember the Chevron hearing, what happened in that. Any law that it is restriction that the administrative court were dictating what those details were, not the judge. And so the court hearing came up saying that that was illegal when states will no longer cannot dictate a vague.
I don't know why it's breaking up.
Law like say business without a business license. Well, they're not public, right? They're not making it, right? So you're saying when citizens, they have to describe who is what citizen, what state, where's the place of business. They have to have descriptive details. If they are not in the past, the administration would dictate what those details would be, and they never had the right to do that.
Okay, so when I started to actually ask questions in that courtroom and even define my rights and who I was, it's not up to the administrative courts to define what the constitutionality is and try to interpret those ordinances as though they were law or constitutional. It's not up to the administrative courts to decide what that is, essentially, is what you're saying?
No. No, they have the right to interpret any law that has specific details. If the details are vague, it makes that law or statute or code null and void because it is detailed enough, and the administration does not have the right to dictate what that is.
Okay. I'm looking at the case right now, and it says, although the Chevron decision, which upheld the Reagan-era Environmental Protection Agency's interpretation of the Clean Air Act that eased regulation of emissions, was generally hailed by conservatives at the time, the ruling eventually became a target for those seeking to curtail the administrative state, who argued that courts... Yeah?
Okay, so this is not a case that was during the time of Reagan. It just came out on June 28th.
Right. Okay, I'm just going to let you speak and I'll be quiet because I have a misinterpretation. I'm trying to understand of what you're saying. The phone was breaking up while you were talking, which I tried to put you on speakerphone or a different speaker, and that didn't help at all. So, what it does say, though, it says, who argued that courts rather than federal agencies should say what the law means. The justices has rebuffed earlier requests. So, is this the same case, or is this an older case that I'm reading? It says the agency stopped the monitoring in 2023 because of a lack of funding. While the program was in effect, the agency reimbursed fishermen for costs of the observers. So Chevron's obviously an oil company or a gas company, right?
Chevron defenses, Roberts explained in his opinion on the court and fire of the inconsistent Proceed Act of a federal law that federal agencies must all instructions from the court and review actions. The APA, Roberts, directed the court decide legal questions to judgment or make it clear for the agency like agency interpretations of the Constitution are not entitled.
Okay.
Different.
So does that mean that the city of St. Augustine, which I have now, okay, under Article, where is it? Right here. Article 1, Section 1.02, it says the inhabitants of the city of St. Augustine, Florida, as its limits are hereinafter established, shall continue to be a body politic and corporate, to be known and designated as. So this is a corporation. It is a corporation. So essentially, they don't have a right to dictate what the constitutionality and the interpretations of the Constitution.
Well, it says agency. Only if the law is vague. Only if the law
is vague. Well, they definitely did take some time writing out these ordinances, because they try to cover natural persons within the phrases, the vernacular of these ordinances. And they're created like they are laws. But even in their own law, it says here, in Article 3, Powers and Duties, Section 3.01, General State Laws. All general laws of the state applicable to municipal corporations now or which may hereafter be enacted, and which are not in conflict with the provisions of this charter or with the ordinances and resolutions thereafter enacted by the city commission. So this is not by legislation, it's by the commission. Shall be applicable to the city, provided, however, that nothing contained in this charter shall be construed as limiting the power of the city commission to enact any ordinance or resolution not in conflict with the Constitution of the state or with the express provisions of this charter. So they're saying right there in their own languages that this shall not be in conflict with the Constitution. So
with the Florida Constitution.
That's right, the Florida Constitution. And then it goes right into Section 3.02 of the same Article 3. It says general powers. And I have Q. General law. The enumeration of the particular powers herein shall not be construed or held by exclusive, but in addition to the powers enumerated herein, implied thereby or appropriate to the exercise thereof, the city of St. Augustine, Florida, shall have and may exercise thereof all the powers which are conferred upon cities by the general laws of which, under the Constitution and laws of Florida, it is and would be competent for this section expressly to enumerate. So, right there, I don't see how they can create an ordinance that says that you need to have a permit to vend when we have an inalienable right to do it. You understand?
Yes.
And it's up to the people to define what a right is and how those rights are to be interpreted. Not the government, nor the city. And then you were saying about the Axon case?
In that situation, the point that goes with the Axon and Chevron is that it is done by the commission. It is not part of legislation. It was not a law that was...
Perfect. So just like these ordinances are created by the commissions and a board of directors, they're not created by legislators. So therefore, they're not constitutional. It's not a law.
Okay, so here's what the Axon says. It says, responded to a separate enforcement act initiated in the security of the Florida Trade Commission. The federal district courts challenges the constitutionality of the agency against them. When as enforced actions against versus Axon, that the institute administrative proceedings to address statute violations. Typically, delegate adjudication, sorry, I can't say that word, to an administrative law judge with the authority to resolve the motion held at a hearing of the issue of the decision. As prescribed as the statute, partly objection of the commission proceeding makes a claim for the first with the commission itself, if needed, blah, blah, blah. Hang on. I'll find it. Hang on 1 second.
No, you're doing great. Thank you.
The court's ordinary field questions the authority to resolve civil actions arising under the Constitution and its state. Axon suits initially meets the same fate, dismissal from all lack of jurisdiction.
Okay.
The district Cochran cases held at review schemes, the administrative review followed by the judicial review in the federal court of the implicit. The district courts and jurisdiction over the challenges of the constitutional ones. Likewise, the district courts found that the FTC's claims concerning the education, confirm, blah, 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 blah. Claims did not receive meaningful judicial review. I mean, the Axon versus FTC was the prerequisite for the Chevron case.
So I would state the Exxon case first, then going into the Chevron case.
And then, yes.
Okay, I'm looking for, because I have a different messenger that I send things to outside.
So it says the statute sets out for the Securities Exchange Act and the Federal Trade Commission Act do not displace the district court's federal jurisdiction over claims of unconstitutional structures that exist. And they're the Federal Trade Commission, right?
Right. Are you reading this from the Cornell Law School?
No, I'm reading from the SupremeCourt.gov.
Okay, maybe you can email me the link or send me the link right now that you're reading from, because it is located on Cornell Law School, which is really interesting. And essentially, I don't know if we're reading the same thing, but it says Michelle Cochran and Axon Enterprise Incorporated respondents in separate enforcement actions initiated in the Securities and Exchange Commission, SEC, and the Federal Trade Commission, FTC. Each filed suit in federal district court challenging the constitutionality of the agency proceedings against them. When, as in the enforcement actions against Cochran and Exxon, a commission elects to institute administrative proceedings to address statutory violations, it typically delegates the initial adjudication to an administrative law judge, with authority to resolve motions, hold a hearing, and then issue a decision. As prescribed by statute, a party objecting to the commission proceedings makes its claims first within the commission itself, and then, in parentheses if needed, in a federal court of appeals. But the parties here sidestepped that review scheme and brought their claims in district court, seeking to enjoin the administrative proceedings. Cochran and Axon concerted that the tenure protections of the agency's ALJS rendered them insufficiently accountable to the president in violation of separation of powers principles. Okay. Axon also attacked as unconstitutional the combination of prosecutorial and adjudicatory functions in the FTC. Each suit premised jurisdiction on district courts' ordinary federal question authority to resolve civil actions arising under the Constitution, laws, or treaties of the United States. So I'm trying to understand what this all actually means. Essentially what I'm getting is that they went into a district court for administrative proceedings, and and challenging the constitutionality of it. It seems to be that the tenure protections of the agencies rendered them insufficiently accountable to the president in violation of separation of powers principles. And then what's that, 28 USC 1331. Cochran's and Axon's suits initially met the same fate, dismissal for lack of jurisdiction. Okay, all right. The district court in Cochran's case held that review schemes specified in the Securities Exchange Act. Administrative review followed by judicial review in the Federal Court of Appeals implicitly divests district courts of jurisdiction over challenges to SEC's proceedings, including Cochran's constitutional ones. Likewise, the district court in Axon's case found that the FTC Act's comparable review scheme displaces Statute 1331 jurisdiction for claims concerning the FTC's adjudications. See, now I wonder if 28 USC 1331 is where we discuss the jurisdiction. Do they have jurisdiction over me, as well as does the proof that this ordinance is applied to me? That was another thing I had asked the court to prove, that this ordinance applies to me. And where's the contract that I signed into? The district court's jurisdiction over challenges. Likewise, okay, on appeal, Axon's constitutional. What's that?
The thing is that you brought those things up and they dismissed it. So that whatever that scene that you were trying to do to prove the contract did not work in your favor. So now you've got to prove their jurisdiction where they don't have jurisdiction in a vague ordinance to tell you whether or not you need a license to do a private business.
Right.
You're not doing you're doing a private business, right?
That's right.
You don't have to do that, number one. Number two, you really need to dismiss their presumption of assumption that you are that legal fiction and that you are the beneficiary and they are the trustees. And you need to put it in writing and stick it in your case that you assigned them to be the trustee. And by law, they cannot do anything to disrupt the benefits of the beneficiary. So to charge you and not let you work to cause, duress, which is American jurisprudence, to the beneficiary, right?
Right.
So that's another thing I would bring. American jurisprudence. This is coercion and duress.
And it truly is.
So these are all kinds of things. I would do a different approach because you claiming where's my contract did not work. So you need to first address their presumption of assumption of who the hell you are. You are not the trustee or the executor. You are the beneficiary.
Okay.
Of that name.
Right.
That you are a living is to be put on record. Number two, you quote case law. Since you quoting statutes and codes are not working, I would be quoting case law. In Axon versus FTZ, in Chevron versus whatever his name is, it states that in these vague statutes, administration cannot give interpretation of what I can do. And here it's saying business. It's not saying public or private. Here is a vague notion. And who's the commission to be able to pass laws? Show me where that is in the Constitution that a commissioner can pass a law. Therefore, it is not law. And I do business with it because of Axon versus FTD and Chevron stating that the commissioner, in this case, who is an agency, does not have the authority to pass a law. And therefore, I have not broken any law, and I need to get back to work because you're causing me coercion and duress under American jurisprudence.
There's also here, too, right here, deprivation of relief benefits under 18 Part 1, Chapter 13. Whoever directly or indirectly deprives, attempts to deprive, or threatens to deprive any person of any employment, position, work, compensation, or other benefit provided for. It's like me out there fishing or gathering for food or whatever. This is how I survive in the modern world. How is it any different? And so, and these do, so, and the right to work is also recognized in Section 6 of Article 1 of the Declaration of Rights in the Florida Constitution. And so, in life, liberty, and the pursuit of happiness. What's the definition of liberty? And then the enunciation of certain rights shall not be construed to deny or disparage others retained by the people. So then I would hit him. I also have a new case law, which I did enact case law, but she was challenging it to the point of incompetency where she said, oh, that's outside our jurisdiction. And so in Article 3, okay, I believe it's like Section 2 of the United States Constitution, talks about how the Supreme Court shall have original jurisdiction. So, and even over these appellate cases. So the administration court should have recognized case law, even though she said that it didn't, it was outside our jurisdiction. It's law at that point. It is law. And there's one that I had discovered. It's called where is it? Penhallow, Penhallow versus Doane Administrators, Doane Administrators, 3 U.S. 54 1L.ed 57 DALLN 54. And essentially what it says, no corporation has jurisdiction over a natural man. And as much as every government is an artificial person, an abstraction, and a creature of the mind only, a government can interface only with artificial persons. The imaginary having neither actuality nor substance, if foreclosed from creating and attaining parity in the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate artificial persons and the contracts between them. And it does boil back down to a contract because they're placing me in a civil jurisdiction. So civil will always break down to some form of a contract. You see what I'm saying?
And they did not honor it.
They did not, well, it's not that they honored it. They needed to provided that there was a contract that placed me in a civil jurisdiction in the first place. Because...
Well, then ask it, put in discovery before the case happened. I want the contract that I signed regarding these obligations to be put in discovery before the trial starts.
I'm going to do it again. Because I already did this, Cynthia. That's why I know I got railroaded. I mean... The video is on 2 different channels, and it's literally the people in the comments are like, wow. And I got a consultant, a lawyer that for $75 for 1 hour, he said he would talk to me and basically go over all the documents that I have just to make sure, I want to do it for a learning experience, as well as to make sure that when I go there, I'm actually being recognized as an individual that is not, I want to be taken seriously by this judge, and how to go in there in a pro se capacity and being able to actually have a real true win with this appeal. So I figured it really can't hurt me if I go in there with some serious questions. If the lawyer doesn't know what I know, then at least I know that. But at least he can go over these documents and kind of go over the way that I'm building my case. I mean, I do have confidence in what I'm doing. I really do. When I listen back over everything that's been done from the moment I met these officers, I let them know right away I don't contract with them. I exercise my rights right from the beginning. I had showed them all my pertinent documents, as well as, I carry my Bible with me everywhere I go. I have all these personal defense mechanisms. So when I say, well, these are spiritual abraxas, and I was operating in a spiritual ecclesiastical jurisdiction, they can't deny that if I ask the officers, did Mr. Siebert have his Bible on him? Were you aware that he was carrying his Bible on him, and that these are all religious activities? And so this also goes within code and the First Amendment and other things that are protecting me between the separation of church and state. And then there's essentially a law I just came across, and it says, Part 1, 18, Part 1, Chapter 13, 247, damage to religious property, obstruction of persons in the free exercise of religious beliefs. So in 2 it says, intentionally obstructs by force or threat or force, including by threat of force against religious real property, any person in the enjoyment of that person's free exercise of religious beliefs or attempts to do so shall be punished as provided in subsection. So everything I was doing was more the Lord's work. And so you can't create a law that goes against those religious activities. So that is another thing that is to be recognized when I do go to court. So not only did I say I do not contract with you, I let them know I'm from the land and soil jurisdiction. I then, when I first met with them, so there's a lot to consider, because I said, all right, well, for the record, I reserve all rights delegated by God and protected by the Constitution and recognizing the UCC 1-308 without prejudice, and that's Florida Statute 671.207. That's the reservation of rights. Also, invoking UCC 1-103.6, which is bringing the Uniform Commercial Code in harmony with the common law, which is also Florida Statute 2.01, invoking the common law, which I have now another, right here. It says 42 USC Chapter 21, Subchapter 1, Statute 1988, Proceedings in Vindication of Civil Rights, A, applicability of statutory and common law. So the jurisdiction in the civil and criminal matters conferred on the district courts by the provisions of Titles 13, 24, and 70 of the revised statutes for the protection of all persons in the United States in their civil rights and for their vindication shall be exercised and enforced in conformity with the laws of the United States, so far as such laws of the United States, so far as such laws are suitable to carry the same into effect. But in all cases where they are not adapted, that's either adapted or adopted to the object, are deficient in the provisions necessary to furnish suitable remedies and punish. So when there's a right, there's a remedy. So even though they say that I violated this ordinance, she should have recognized I have a right, therefore I have immunities, privileges and immunities. And that there's a remedy. Where there's a right, there's always a remedy. Where there's a remedy, there's always a right. So if they're writing ordinances that don't align within some kind of applicable remedy, then there's no remedy to the recourse. Therefore, it's outside the common law. Therefore, it's unconstitutional. So it says to furnish suitable remedies and punish offenses against law, the common law as modified and changed by the Constitution and statutes of the state, which happened in 1968, wherein the court, having this jurisdiction of such civil or criminal cases, criminal cause is held so far as the same is not inconsistent with the Constitution. So right then and there, they're discussing how laws must be formatted, okay? And laws of the United States shall be extended to govern the said courts in the trial of the cause, and if it is of a criminal nature, in the affliction of punishment on the party found guilty. So trial and disposition of the cause, and if it is not of a criminal nature. So this is not a criminal nature, and it appears that under this statute that I just said, U.S. 42, Chapter 21, Subchapter 1, Statute 1988, it's very apparent that when laws are made, they have to be in harmony with the common law, as well as the Constitution. Because the Constitution is what protects everybody within the natural and the common law, which means that everybody has a right, and then through contract and statutory procedure comes where all these color laws come in that then convert everything into privileges and basically creates all this mayhem that we're dealing with right now. That's my interpretation of everything. Would you say that sounds pretty accurate?
If you want my opinion, I would say no.
You say that does not sound accurate?
No, you cannot mix common law. It's a different jurisdiction, right? It's a different jurisdiction in an admiralty law. There is no harmony. If you were to go into court case and it went to file a claim under civil, criminal, right? That's all underneath admiralty. To be in common law, you have to be in a common law court. That is the only who has concurrent jurisdiction over other cases. They are the only one that does that.
Well,
You go into they may give you statutes and codes, but that is for their employees. That's not for you. That's for them to abide to, but they're not recognizing.
because we don't have common law courts, we can invoke the common law in the court and move the court to a common law procedure.
Has it worked yet?
So far,
I don't know.
it has not been recognized. I am doing my best to enforce the common law in these courts. Yes. And to stand on that.
I don't know anyone who's done it.
So far, you don't know anybody who's done this.
Who has been able to invoke common law in an admiralty law court case.
I'm gonna do my best, by moving the court into special proceedings, and then invoking all the statutes that I did. Now I have case law that we're gonna work with, of the ones that you have suggested to me, as well as the one that I have with the Penn Hollow versus Doan administrators about, constitutionality, as well as how no corporation has jurisdiction over a natural person or a living man, a natural man. So
right.
Then, within common law is how we got remedy. So if I have to, I'll announce that to the judge. Be like, we can't ever ignore the common law. Never. It is always existing.
And you need to be specific. It's American common law.
American common law, that's right. I'm with you. Yes. American common law, under the American jurisprudence and the corpus juris secundum. Yes.
Yes.
Yes. A positive law. That I'm not backing down. I'm going all the way. Okay? I truly am. And I'm writing down all these notes right now so that when I build my affidavit, this is the language that we're, kind of building off of. And, it's written in their codes. I find it and see it all the time. The common law, without the common law in the Constitution, the same rights that afforded and protect us is the same rights that afford and protect them when they take off that uniform, when they take off that robe, and they choose to be, a national or, a state citizen or whatever they want to go by. These same rights that protect us is what protects them. This is what gives the government reciprocity to function the way that it does. They're mirroring our sovereignty and then while eliminating our rights. Do you understand? They're trying to eliminate our sovereignty while without our sovereignty, they would have never had the sovereignty that they have, the sovereign immunities that they have. And, I get it. You shouldn't mix public and private together. This is what they say. But if we're going to coexist in this world, there has to be some kind of diplomat. When I was in Maine, the lieutenants and the people and the sheriffs, I was talking to these people all the time trying to get it so that if we're freely traveling down the road and you see us, are you going to beat us up, steal our property, and throw us in jail? And it came down to a unanimous decision that if we, as an assembly, could create our own, contract to let them know that there has to be some form of laws that we do follow, to a degree, and that we all have to have certain agreeances, because when they're dealing with people, none of it is the same. Each person is governing theirself, therefore their language is different. I've talked to a few cops already just recently, and the way that the conversation was going, I went ahead and reserved all my rights, and they were like, "What are you, a sovereign citizen?" And I was like, it almost feels like a hate crime. I was like, it's okay if you cut your penis off and call yourself whatever you want, but I call myself a national or a sovereign, and oh my God, I'm a terrible human being, and I don't have any rights anymore to back me up, when all those rights were already there and intact. But I can cut my penis off, and now I have the government to back me up, and somehow I have civil rights to, back me up so that I'm not being suffered by any kind of hate crime or whatever, and discrimination. But I call myself this, and they're like, you got a point there. And what they were saying is that some people take this stuff to an extreme, and where, it's just, it seems outlandish, which then makes us appear to be insane or radical or whatever. And again, freedom is dangerous. It really is. I mean, absolute freedom and free autonomy and independence. And that's why I tell people, I say, listen, it's God that brought me here. And when you walk with God, you're walking different on the earth than you are trying to, be, above the law and acting dangerous or a radical or, in a sense of where essentially you're putting your life at risk and other people's lives at risk at the expense of what? Your freedom? When you walk with the Lord, you walk with love and peace and honor and dignity and integrity. So the last thing you're trying to do is hurt anybody, and common law always breaks down to common sense. So they're dealing with different walks of life when they're dealing with this. That's why I think it's going to be important once we get our courts up and running and at least a sense of our own jurisdiction, and we create, at least our own decals and license plates. There has to be some kind of, which I know that they do. They have the scripts and everything of how to deal with police officers and stuff. It is admirable of individuals like you and myself and Giles that take the time to study these scripts and, to operate peaceably. I still think that, one of the greatest issues I have and discrepancies is that we call ourselves a free people, but we're afraid to give up our license plates. And then I do feel like we're growing in numbers, and they're afraid of us because we do know the truth. And they're like a tick or something, They survive off us depending on them or being a part of the system. And every time one person leaves the system, they lose that authority and that power over people, and they don't know what to do. It's like the movie The Matrix, waking people up out of the Matrix and pulling them out of Babylon, which is what we're supposed to do. But if we can have a sense of diplomacy of where, logical, rational people not only typing up affidavits in these instruments that we are reading from, Anna herself and what Ralph reads off during the presentations, as well as you and Giles. These things need to be brought to, our governors or the governors on their side. Should we elect our own governor? Should we have our own, legislator of the several states, as well as the legislation of the district? And when you call these people, they say, oh, we're in District 9. You need to get a hold of somebody from District 5. It's like, what? So they're already breaking up all their representatives as individuals that truly are a part of the de facto, working for the de facto, representing the de facto. Where's our du jour candidates? And there should be a Continental Congress reestablished.
There is a Congress, but we're not there yet, right? So we first have to do the 4 pillars of the assembly. So that is part of the due process too. We are unincorporated, right? They're incorporated.
Right, you are right.
How we proceed forward is to fill our 4 pillars, get our state court up, invoke ex parte Milligan, then we move to Superior Court, right? Then we go to Continental Congress, and then we form our Superior Court. So they're all step 1, step 2, step 3, step 4. So we're in a process as fast as we can with qualified individuals doing as much as we can. And we are populating, but we are incorporated. We are not corporated, right?
Right.
So we So it's going to look a little different, right? You know, when you look at the Florida Constitution, you'll see the General Assembly does this, the General Assembly does that. We are the General Assembly. Right?
We are.
We are the unincorporated de jure government. They are the de facto incorporated with a contract to do a job, right?
For us.
We're here to people to get their voice heard and to make sure that they are doing their job.
So, do we have people on the ground working? That's what I've been basically doing, is because I started off in Maine, and there's not a lot of people, you know, letting their officials know and taking stand. It's almost like they're afraid or something. I mean, the FBI went and shut them down and thought that they were domestic terrorists and stuff, and almost shut down the entire assembly. And so I took it upon myself to start calling these individuals, you know, holding them accountable. Under statute 29A, it's 29A 109, statute 109 in Maine, out of the Maine statutes, it's reciprocity and talking about exemption of licensing and registration to private automobiles. Why doesn't Florida have that? How come Florida doesn't have that written in their statutes and codes? Now, I've been looking for it, and it's very vague, as we were saying earlier, but a lot of it's in there, like private use, okay? Not for hire, all right? They do have certain kind of exemptions for jurisdictions, but they're using that for their city and their municipal automobiles, their motor vehicles that they're using to patrol us and to have their authority against us. They are writing that in their own laws, but how does that apply to the people? And again, you know, it's like I was telling my my aunt who's 63, I'm letting her know it was 1968, 1967, in some states it was right around 1965, when they proposed to all the people that they were going to revise the constitutions to make them better. And then this is where they took all the old constitutions that were built for the people and bound the government and shrank their authority, that limited them. They then wrote in these statutes and codes our enslavement, while then giving themselves all the privileges and the immunities and the sovereign capacity to somehow have authority over the people. And then here we are now, 2024, look how bad it's got. So, and it is the debt. There's, you know, it's the economy, it's the debt. They're trying to inflate the dollar and do away with it completely and move us into a digital age. And so I have faith, I really do. I do believe that we're going to get ahead of this, and we are going to hold people accountable, and we will bring back constitutional money. We will bring back, you know, the republic. We're going to restore the republic. And then we can start holding these guys accountable. And then the only thing is if we're dragging them into our courts, then they also have every right to due process of law as we do. You see what I'm saying? And we got to do it better than them, because they're using us to extort money or to pay their debt under the chattel paper, over the patents, you know, the letter of patents and the letter of credits, which are our birth certificate, social security number attached to our Sesquier V trust, basically essentially using us as debt slaves and placing us in the position of a trustee versus them. So, yeah, you know, when they come into our courts, are we going to extend mercy to them like we wish that they had extended mercy to us? These are good questions, don't you think?
Well, I think that a lot of them need to have their feet taken to the fire. A lot of them need to be responsible and accountable for their actions. So I feel that in the next coming whatever, as time goes by and we get our courts up, that we will be taking the DMV to court. We will be taking the governor to court. We'll be taking the county court to court for not what we paid them to do, right?
You're right.
We're doing everything in their benefit instead of for protecting our rights, which is what we paid them for. They did it for their own personal gain and profit. So I don't know if mercy would be shown to them.
I think it was going to fall under the level of treason because.
Yeah, they're trying to kill us. I mean, why haven't we passed any laws, not statutes and regulations, and laws about the chemtrails?
Chemtrails.
Why haven't we talked over the pesticides?
Monsanto.
You know what I mean?
Yep, Monsanto.
You know, I mean, they're trying to kill us, and there's states that have done that. They have taken out the chemtrails, they've stopped the daylight saving times, they've stopped the pesticides, and here we are, twiddling our thumbs in Florida. What the freaking frack? I mean, Defacto has been really great as far as the de facto governor, but he has a long, long way to go.
I mean, personally, all you hear on the news in Maine is how impeccable Florida was for not, taking the shots or standing against the government and not following any of the mandates. But you get here, and I'm not going to lie, the demeanor of people, the way that they're, it's like, and I don't know, it makes me, I can't hang around with them. I really can't. They still believe they were just as affected by COVID-19 moving forward. I guess there was some implications being forced masks, and this is probably why people stood up and said no more. And it is sad how everybody wants to complain but don't want to do anything about it. They look at Trump as though he's going to be the hero to save the day when, I'm sorry, so they're wrapped up in the politics of what's going on in Washington, D.C., not in their local community, not in their government. And Florida has had years of this corruption going on, building up to where it is now. I will say, by the grace of God, there is a real movement. I can feel it. We're at a very special time in history right now where the people can retain their power back. We can. I think by COVID-19 and this vulnerable position of what's going on with the administration, so between the failing attempts of all the psyops and the psychological warfare that was implicated on the people from COVID-19, the mandates, dividing the people and calling them essential workers and non-essential workers. So they already created the Civil War, already right away, by the implications of COVID-19. By people standing up for they brought people to now where everyone is paying attention to the Constitution. They're paying attention to every bit of esoteric, theological information. People are studying the Bible. There is a huge, massive spiritual awakening happening. And there is a lot of people that are essentially, hands down, not trying to judge or anything or really label anybody, but just evil. There's evil people out there. And Florida, I think, is at a crossroads, if you want to know the truth, between this. I think actually the Nationals are growing in numbers. We're trying to figure out the right proper remedy when we move forward in court. See, what we need is case law. We need to not have them dismiss the case. We need them to go all the way to the Supreme Court and win that way. Whether it's traveling with an automobile, a lot of people independently get these cases dismissed. And yeah, they won, but it doesn't stop everybody what they consider a mob rule or the democratic, because the democracy is usually 60-40. And so the more percentages that we have on our side, like Maine, they had to legalize weed. How come? Because everybody was smoking weed and growing weed. What are they going to do? Arrest everybody? They can't. So they changed the law. And then down here, they're kind of slowly doing the same thing. But, I love the idea of us having our own jurisdiction, our own courts, our own government being maneuvered by the people and not by them anymore. And then we, the people, can start holding these corporations, like you said, accountable. The DMV, Monsanto, chemtrails, any of these vaccine companies and their advertisements. And, we know that there's going to be harmful adversarial effects later on. So why are we even allowing this stuff to be propagandized to our children? Um, you know, the list goes on, actually. It really does. And so, if we can have the ability to take the power back and start using, like, holding all these, again, it doesn't matter whether you're a corporation, you immediately get signed in and enacted through all these other specific statutes and all these other codes that and charters that allow you to have your artificial existence, but it's always going to be from the Constitution and common law, and all that is derived from the people. So this is why I don't understand how they're not recognizing the common law anymore. When did this happen? When did it start to get this way? When?
I actually don't know the exact date when all the common law courts got shut down, but they did it one by one by one. And all the constitutional common law, American common law judges retired one by one by one. Each one was replaced by an admiralty court, and we didn't stop them, you know. So it was our duty to object, and our silence meant,
Was our
you know,
consent.
that we accepted.
I'm going to do this case as best as I can. I am not the type of person to elevate myself to some kind of throne or position. I'll let God do that. But I'm going to focus on this case, and I'm going to win. I'm just going to keep throwing it out there that I'm going to win. And when I do win, I am going to hold them accountable, but I am going to come in with, you know, with true perseverance, that I will make it a mission to truly stand for my daughter, your grandchildren, and all your children's children's children. And we are going to restore this republic. We're going to do what it takes to be a pillar standing for what our forefathers fought for, what this country really stands for. And it's not just going to be about me. It's going to be about all of us. And again, you know, I'm confident to learn. I'm confident to know when I make a mistake and how to correct it. I'm willing to tell you when I don't know, and then when I'm willing to learn. So I don't see why I would not be able to be an asset to our future moving forward with the General Assembly. That I truly will do whatever it takes. You know, I mean, you know, I'm doing a lot of shadow work right now and a lot of facing myself. So it's like you're facing the worst of yourself and the best of yourself at the same time. And it does take sacrifice. It takes a lot of things to continue on with having cognitive, you know, cognizance, your mental capabilities to constantly keep going forward, learning and learning and learning and learning. I think there has to be a balance between having fun and then working. And, you know, right now our country really is in dire straits. This is what it needs. And this is what I actually have, you know, purposed myself with since 2014, is to educate the public the best I can. Then realizing I was just trying to wake myself up, the moment that I allowed myself to give me the power and take the torch away from my elders, that, you know, I'm not going to contribute any further towards the religion of Babylon or towards this system in any way, because if these people had good intentions, we would have got there by now. Every one of my ancestors have voted all the way to where we are now, and look where our country is at. So why would I continue to participate in any of this, the shenanigans, the chicanery that's been going on since the 20s, since the 1900s, when it first all began in the 1900s, since 1871, you know? There's been many quotes that I've been privy to. One of them was an individual, I forget his name, but he said that we're going to own all your biological property and Americans will unwittingly sign over all their own property and eventually will own everything and everyone. And anybody who becomes, you know, aware or in the knowledge or in the know of this great conspiracy will be deemed crazy, and we will always have behind us, backing us up, plausible deniability. To be able to deny them, call them crazy. They're kooky. I forget who that was that made that quote. We will get the American people to sign over their biological property. Speech or quote. I'm trying to think of what book it was that I read it in too. I have another book. Edward Mandell House said to Woodrow Wilson, very soon, every American will be required to register their biological property in a national system designed to keep track of the people and that will operate under the ancient system of pledging. By such methodology, we can compel people to submit to our agenda, which will affect our security as a chargeback for our fiat paper currency. This is where they created the Sesquique v. Trust and having people back their currency. Every American will be forced to register or suffer being able to work and earn a living. They will be our chattels, in parentheses, property, and we will hold a security interest over them forever by operation of the law merchant under the scheme of secured transactions. Americans, by unknowingly or unwittingly delivering the bills of lading, in parentheses, birth certificate, to us will be rendered bankrupt and insolvent, secured by their pledges. They will be stripped of their rights and given a commercial value designed to make us a profit, and they will be none the wiser. For not one man in a million could ever figure out our plans, and if by accident one or two should figure it out, we have in our arsenal plausible deniability. After all, this is the only logical way to fund government, by floating liens and debts to the registrants in the form of benefits and privileges. This will inevitably reap us huge profits beyond our wildest expectations and leave every American a contributor to this fraud, which we call social insurance. Without realizing it, every American will unknowingly be our servant, however begrudgingly. The people will become helpless and without any hope for their redemption, and we will employ the high office, presidency, of our dummy corporation, in parentheses, USA, to foment this plot against America. And this was 1871. Well, actually, it was 1913 and 1921. So, Edward Mandell House said in a private meeting with Woodrow Wilson from the private papers of Woodrow Wilson. So, that essentially is... Yeah?
I have somebody, family, calling in.
Okay, thank you so much.
You can talk, tomorrow, and I did send you that stuff by email.
Okay, thank you. Yeah, I'd love to talk tomorrow.
Yeah.
Okay.
Okay, I'll talk.
Okay.
Okay,
Bye.
bye-bye.